This is Javon Williams presenting the 2020 Seacrest Wordle Premises Liability Webinar Series section for Notice, Knowing What Was Wrong. In Michigan, a possessor of land is subject to liability for physical harm caused to his or her invitees by a condition on the land if he or she knows or by the exercise of reasonable care would discover the condition and should realize that it involves an unreasonable risk of harm to such invitees and should expect that the invitees will not discover nor realize the danger or will fail to protect themselves against said danger. A possessor is also liable if they fail to exercise due care to protect against the condition on the premises. Also, a possessor of land is not liable to his or her invitees for harm caused to them by an open and obvious condition, that is, unless the possessor should anticipate harm despite knowledge of or the obvious nature of the condition. The duty owed depends upon the claimant's status. Therefore, claimants must fit into one of three categories: an invitee, a licensee, or a trespasser. The invitee. An invitee warrants the highest level of care. A common example would be a retail guest. An invitee is owed three duties: the duty to inspect, the duty to warn, and the duty to make the premises safe. For example, a storekeeper should check to ensure that the aisles are safe for their customers to travel. The licensee. This category includes social guests. Landowners owe licensees a duty to warn of dangerous conditions that the landowner knows of or has reason to know of if the licensee does not know of the condition. A landowner does not owe a licensee a duty to inspect the premises nor to make the premises safe. For example, you should warn a friend about a faulty basement step that you know of that the friend has no reason to know of. The trespasser. Landowners generally have no duty to warn trespassers about conditions on the land. That said, as a landowner, you should probably refrain from intentional acts aimed at injuring trespassers on your property. Michigan does, however, recognize an exception to the general rule for child trespassers. Landowners may be liable for conditions found to be attractive nuisances on the premises. Here's a checklist. A. Is there an artificial condition on the land where the possessor knows or should know that children are likely to trespass? B. Could the condition involve an unreasonable risk of death or serious injury to children? C. Is it likely that the children, due to their youth, may not discover or appreciate the risk involved with the condition? D. Does the risk to children created by the condition outweigh the landowner's use of the condition or their reason for not eliminating the condition? Here, there may be a cost-benefit analysis. And E. Did the landowner fail to act reasonably to eliminate the danger or to protect the children? Examples of duties owed to business invitees. As previously mentioned, storekeepers should provide reasonably safe aisles for their customers. Also, storekeepers will be liable for injuries caused by an unsafe condition that was caused by the storekeeper or its employees, or if the condition has existed for a time period such that the storekeeper should have discovered the hazardous condition. Snow and ice removal. If the business invitor is on notice of the accumulation of snow and ice, then reasonable steps need to be taken to diminish or remedy the hazard. Criminal acts of third parties. A merchant's duty is to reasonably expedite the involvement of the police once criminal activity becomes apparent. The merchant has no duty to anticipate the criminal acts of third parties. A few key notice considerations. Areas to focus. What condition is involved? Did the store owner or the employees cause the condition or contribute to the condition? Did the store owner or the employees know of the condition? When did the condition form? How long did the condition exist? Should the store owner or the employees have known about the condition? The frequency of the condition or similar conditions on the premises, including the location. Who or what caused the condition to form? When did the property or premises owner become aware of the condition? Some best practices for documenting incidents on the premises. Track how the condition came to be. When did the condition begin? When did the condition end? Obtain photographs of the area if at all possible. Track when the area was initially inspected. Track the methods of reporting. Document the people working or witnesses to the incident if possible. Importantly, our Supreme Court has held that it's the plaintiff's burden to establish that the defendant, possessor of land, knew or should have known about the alleged hazardous condition. The premises owner does not have a duty to produce evidence to disprove the plaintiff's claim. However, a plaintiff need not prove notice if there is sufficient evidence that the premises owner or its employees caused the condition. In closing, it's important to note that new opinions are issued by our courts on a regular basis. You should contact your counsel to ensure that you remain abreast of the trends and changes in the law. Thank you for attending the Notice, Knowing What's Wrong section of the Premises Liability webinar series.